Hi, everybody. Thank you for joining us for another edition of Condo Insider on our very own YouTube channel. And today, what I have with me is John Morris. At Hawaii Council, we've been getting a lot of questions regarding committees. And it's really kind of started getting more, the amount of questions started coming in after we started to do more education about 514-125A, which requires owner participation. So there's been some dialogue going around where some boards are creating committees to sidestep the 125A in that process. So we want to really have John Morris kind of guide us onto what the committee can and cannot do and what their role should be. And then we're also going to talk about House rule amendments. So John, let's start off with committees.
Okay. Yes. So I'm just going to give an outline of the background of board committees. And the main problem is that the condominium law says almost nothing about committees. So if you look, we've put on the screen, the only real reference in the condominium law to committees is a provision that says the association can provide indemnification of committee members in the same way that it might for board members. But that is the only provision. Now, some bylaws, although not a lot of condo bylaws, do authorize specific committees, and those bylaw provisions may say what the committees can do. Sometimes it's like design review, that type of thing. And sometimes it will also say that the board can delegate authority to the committees to implement board decisions. But again, the condominium law is not very specific. So if you want to see whether your bylaws do restrict or authorize or limit committees, you probably have to check there first. Because if not, you're not really subject to any specific restrictions. But one thing we often do mention to condominiums, even though it doesn't apply directly to condominiums, is there are provisions in the non-condominium law, in the homeowner association law. But one thing I would like to emphasize from the very beginning is the condominium law does provide for supervision. The owners are supposed to supervise their boards, not the real estate commission or everybody else. It's supposed to be the owners. And the only way they can effectively do that is to attend board meetings and see what the board is doing on their behalf and make sure the board is following the rules. So that's one of the reasons why committees should not be used to avoid that principle. So we just are mentioning to you that for whatever reason, the legislature has set up some standards for committees when it comes to planned community associations, which are usually homeowner associations. So it does say the board may appoint. And again, this is not the condominium law. This is chapter 421J for planned communities, but it does say the board may appoint committees or subcommittees to review and consider specific matters, and may alter and eliminate the committees, provided that the board, in the minutes of the meeting in which the action is taken to appoint a committee or subcommittee, shall include the following three things: report that the committee or subcommittee was appointed, identify the members of the committee, and describe the matter that the committee or subcommittee is to review and consider. So even if you are not a planned community, if you're a condominium, you should seriously consider that as a condominium board if you are going to appoint committees. So I think that's one of the things that you would want to be careful, is because it gives you a basis of what you've done. You can say, well, even if it's not in the condominium law, the legislature has approved this as the best way of appointing committees. And so that's not directly applicable to the condominium law, but gives you an argument. Now, this is, strangely enough, this is a useful provision from the Robert's Rules of Order, which says when a special committee is appointed to implement an order of the assembly, in this case, the board would be the assembly, it should be small and should consist only of those in favor of the action to be carried out. If anyone is not in sympathy with the action, anyone not in sympathy with the action is appointed, he should ask to be excused. Because this is a common reason to have a committee. You'll have 7 board members, 5 of them will be in favor of investigating or researching an issue. 2 of them won't. So this provision from Robert's Rules gives the board justification for saying, well, if you're not even in favor of doing this, we're not going to appoint you to committee, because it's just a means of allowing the committee to function more efficiently if the committee members are those who are willing to at least investigate and report back to the board on what the committee has found. So that's a point worth remembering, because that is often a point of contention when the board appoints a committee. And again, so this is who creates a committee. Again, we would take the position the board can create the committee, but they derive their authority from the board's authority, unless, again, you have something specifically in your bylaws or possibly your declaration that says the board has authority to create a particular committee. If you don't have that, then basically the committees, their authority comes from the board's authority, so it's limited in the same way. And typically, so that's basically what this slide is pointing out, that the committees cannot take over the role of the board. They only have the authority the board has given them. And again, that is outlined in that section we just cited from the 421J. What is the role of the committee? We emphasize this heavily because, again, a committee should not be appointed to undermine or avoid the self-governance provisions of the law, which requires owners to be present when the board is making decisions that will affect the owners. So our standard position is the committee can only make recommendations to the board. The board then considers the recommendations and decides whether to follow the committee's recommendation, change it, or reject it. So that's the guiding principle of a committee. They can only make recommendations. They can't decide issues for the board. So again, the ultimate decision the board makes based on a committee recommendation has to be consistent with Hawaii law, has to be consistent with the declaration and bylaws, has to be consistent with county ordinances, state law, the condo law, or federal laws. So again, we can't say often enough, you cannot use a committee as a board to avoid the requirements of letting owners know what you're doing. And so this is part of, and again, what the board decides based on the recommendation is still subject to standard limits on what the board can do, high law, declaration bylaws, county ordinance, federal law. Okay, next.
And this is where too, you, if it's a committee, maybe they're making House rule amendments and the committee recommends this, but maybe there's a question on what one item that might be on the borderline of maybe fair housing or something like that. And this is where the they also have to engage their legal counsel for
yes. Well, that's very true. I didn't want to say that like I was making work for myself, but it is true. Unfortunately, if you're on a board, you do have quite a lot of authority, but you also have limitations. And you just have to be careful. And as Raylene mentioned, particularly in connection with fair housing laws, you can get into trouble. Restrictions on children, restrictions on occupancy, restrictions on people who may be disabled. So that is something, leaving aside all the rest of it, if you're in any of those areas, if you're adopting rules, it's best to run them by the association attorney just to make sure you're not adopting a rule which will later get you into trouble under the law or the governing documents or that type of thing. So that is true. Yeah, that's a good point. Okay,
Yeah,
next
and
slide.
also even I know in the past we had these conversations, even signs. If you point out or mention something about children in a sign, that could lead to a civil rights violation. So I know how you word signs are sensitive issues as well. Even as a just like fair housing, how you word signs. If you put no children can play blah blah blah, you're actually being discriminatory toward the kid. So you really have to get legal counsel to make sure about the wording of your signs as well.
Yes, the problem is even if you don't enforce them as written, the very fact that you put something on a sign or in your rules that might dissuade someone from exercising their fair housing rights, that can be deemed a violation. Again, even if you don't enforce it, if it's there, if it's stated in writing on a sign or in your rules, that can be considered a fair housing violation if it singles out children without a health and safety reason or something like that. Okay, and again, we just want to emphasize the role of a committee. The condominium law states that the vote of the board members, except executive session motions, is supposed to be recorded in the minutes. And that's emphasizing the self-governance aspect that the owners have to have a right to be there when board members are making votes on their behalf. So it is something to keep in mind. Yeah. Yeah. So who can be on the committee? This is often a question that comes up. There's no reason board members can't appoint owners to be on committees, particularly if an owner has some area of expertise that will help the committee function, or simply for political purposes. In other words, so the board can say, no, we're not just jamming this down your throat as a board. We brought owners onto the committee to get feedback from the owners. But again, we come back to, is a committee meeting a board meeting? We usually take the position that it is not a board meeting if the committee is just discussing things and going to make a recommendation to the board. Because if the board is going to make the ultimate decision, not allowing owners to attend a committee meeting doesn't necessarily violate the law because there's no decision being made. Again, 5-4-B 126A focuses on decisions, not on discussions. That's a common problem. You can have a half-hour discussion at a board meeting, but ultimately the minutes are supposed to reflect what the board decided, not necessarily what they discussed. So there is something of a dispute on this. Some owners take the position that committee meetings are simply a way for the board to undermine self-governance by keeping the owners out of the discussion of the board on an issue. That's particularly the case if the committees comprise the board members. But again, the issue from our point of view is who is going to make the decision. And if the committee is only discussing things, making a recommendation to the board, that's not a board meeting. And so the law doesn't say that the owners have a right to attend committee meetings. It just says board meetings. So but that is an issue that there are differing opinions on that. You should be aware. So you may want to check if you're an association, check with your own attorney to see what they say. But again, a lot of times committee meetings are just to allow a discussion without taking up a lot of board time, so the committee can say, we researched this, we decided this is our recommendation on how the board should act.
And sometimes committee meetings could be helpful if there's like an issue, because you don't, and it might help to minimize the discussion time during a board meeting. Because I've heard some people have like 4-hour board meetings. I'm like, holy smokes. And a lot of it was discussion, owner participation discussion, but maybe depending on what the subject is, a committee can be formed to help ease the I don't want to say the word burden, but can help minimize the discussion time during a board meeting. But a committee meeting can help to centralize the main issues of the owner's input. Did I say that right? Or at least help
Yes.
put it in
Uh,
a more concise manner to present to the board. These are what owners have issues about, and then go from there.
yes. Well, that is one of the concerns. Sometimes boards are faced with issues that have a lot of background complications that they don't necessarily know. We would certainly advise a board, don't make a decision unless it's an informed decision. So sometimes the board will say, we will appoint a committee to look into this particular issue, find out more information for us, and report back to the board so we can make a more informed decision. So that's often the role of a committee, is to research issues for the board so that they can make an informed decision rather than just a seat of the pants. We'll do it this way without knowing the full background. So that's one thing. So this is the slide I was just talking about, which is there are people who say, well, if the committee is comprised solely of board members, then it must be a board meeting. And again, it's not so much who's there, it's what they're doing. If they're just researching a difficult issue and trying to determine what's best for the board, and they're going to make a recommendation to the board, even if the committee is comprised solely of board members, it doesn't necessarily make it a board meeting. So that's one thing to keep in mind. And so this goes into a little more detail. So the board can make a decision. The second purpose of a committee is to implement the board's decision. If it's a fairly complex decision, or if the board as a group, say there are 9 members, they can't all be involved in implementing the board's decision. Sometimes a small committee will be appointed to implement that decision. And it's essentially the same as if the board was asking employees to take care of something, or the managing agent, or even a contractor. The person is still acting for the board based on the board's instructions. And that would be the case if the board decided to appoint a committee to implement what the board has decided. So that's part of the maybe a secondary issue. It's not as common as research, but again, sometimes the board says, this is the board's too big to all be involved in trying to make this decision work. So we're just going to appoint a few board members to oversee getting this decision implemented so we can move on. And again, the decision, the committee is not being given authority to do whatever the hell it wants. It's being given authority to do what the board has decided to do. Now, sometimes when you have a committee, people may have seen this, the committee gets a bit carried away and it goes beyond what the board has asked it to do. That's not okay. And so the board, if that happens, since the committee is created by the board can emphasize what the committee is going to do, or just say, hey, we're sorry, you guys are way beyond what we wanted you to be doing. So we're going to disband this committee and we're going to have someone else take that role. So that's kind of what this slide is saying. The committee, if it's going to act for the board, has to act within the authority given it by the board. And it's not supposed to actually make a decision, maybe very small decisions, but it's supposed to implement the decision the board made. So it's important that if you get appointed to a committee, you keep this in mind. It's not do whatever you want, it's do what the board said they want you to do. So I think that's something to consider.
And just like board members, even if you're just on a committee meeting, you still have to also keep you're working and acting in the best interests of the association as a whole, right?
Yes, you would be considered you'd be subject to the business judgment rule. Your decisions as a committee member would have to be reasonable and made in good faith, just like board decisions. That's true. Yeah. Okay. And then one common problem we have is many people think that there's a sunshine law that applies to homeowner associations. and condo associations. In fact, the Sunshine Law applies, the state law applies to state or county board meetings and says if more than, say, two people meet to discuss something outside of the state or county meeting, that's a violation of the Sunshine Law. And again, the purpose of the Sunshine Law is to make sure owners are aware of what the particular state or county board is discussing. But it doesn't apply to condominium or homeowner associations, and we've actively lobbied against that being the case. We say, hey, look, these are volunteers. People are doing this to help their fellow owners. If all their fellow owners can talk about things relating to the condominium outside of a board meeting, why can't the members of the board? Because again, the focus is always on board decisions, because board decisions are what affect the owners. So there is no Sunshine Law dealing with condominium or homeowner association boards. So if you're on a board and the owner tells you you're subject to the Sunshine Law, they're not correct. So just to make that point clear, that you as a board member can talk to a fellow board member about things, but again, you cannot be making decisions, because then it's a board meeting that's not following the proper rules.
Okay, so let's go on to the next section that we were wanted to talk about in this Condo Insider, which is house rule amendments. I get a lot of questions about how they can do it and also the process. So I think there's some condos out there that might be just changing the house rules, but not giving proper notice. And even the way I always remembered it was if you're going to do a house rule amendment or a change or an update, you send it out, and do you provide the owners an opportunity to respond back or comment back on the changes? So let's go through that process.
Yes. So the problem always is it's easier for the board to amend the house rules than to amend the declaration and bylaws. So you're right, some boards want to use the house rules for things which should properly be in the declaration of bylaws. But anyway, the three issues facing a board is the process under which the house rules must be adopted. That isn't really spelled out in the law. It's generally spelled out in the bylaws. And then the second issue is what you can put in the house rules, the content. Third issue is enforcing the house rules. So those are the three considerations facing the board if they want to amend the house rules. And then one of the issues is, since there is not a procedure in the law about amending the house rules, it usually depends on what the house rules say. It's very common to have a provision in the house rules that the board must give notice to the owners in the same way as they would give for an annual meeting, which is minimum 14 days, and then give owners an opportunity to comment on the proposed changes. So that is not in every set of house rules. I mean, so every set of bylaws. Some bylaws just say the board can make a change. So that has to be, you have to look at your bylaws to see what the process should be. And then even if you look at the process, there is the background principle of due process, which means that, for example, you can't amend the house rules and then enforce them the very next day against an owner without giving them reasonable notice. We usually suggest at least 30 days after an amendment is made before the board starts enforcing. But again, the law does not really deal with the process of making amendments, except as we're just going to talk about. So the board has to follow what the bylaws say. And as Raylene said, many of them say that the owners have to first be given notice of proposed changes and an opportunity to comment, either at a board meeting, which is quite often how it's done, or in writing. So that's one of the issues. I've even seen a few sets of bylaws that required owner approval of the house rule changes, but that's not very common. And
That
then
would
when
be
the board is starting the process, this slide outlines the basic challenges and considerations, which is whether the board has exceeded its authority to make a particular rule, whether the house rules contain any potential fair housing problems under the federal or state law, and whether they're sufficiently clear, because sometimes they do contradict each other or they're not clearly written. So I think that's one of the issues. And then if we go to the next slide, you will see that the condominium law, if you look in 104A1, it says the board can adopt, or the association can adopt rules. 106 gives the board broad authority to act for the association, but 105 outlines some of the restrictions on what the board can use the house rules to do. So that's something the board has to keep in mind. And so I think if we go to the next slide, the wording of 105B is there. So that says, unless the declaration of bylaws permit, the house rules are only intended to, they're not intended to affect the use or behavior of units, of residential units. And so what it says is, they can prevent the use of the unit which violates the declaration or, of course, the bylaws. They can regulate any behavior or occupancy of a unit that violates the declaration of bylaws or unreasonably interferes with the use and enjoyment of other units of the common owners. And they can restrict the leasing of residential units to the extent the rules are supposed to meet underwriting requirements about the use of units, like for residential purposes, that type of thing. But otherwise, the house rules under the law, this section, they are not supposed to be used to regulate the use of units. Now, of course, if you have a provision, a lot of associations will have a provision about putting stuff on the lanai or changing the external appearance of the unit. The board can put that in the house rules because basically it's only alerting owners to a restriction imposed by the bylaws. But generally, the house rules are supposed to be to control the common elements, not the units. Okay.
What about for in instances where the unit owner or even the tenant is actually conducting business within the unit?
Well, that would generally come back to, I mean, if you have that going on a wide basis, you're in a project where a lot of owners start doing that, it might be a good idea to put that restriction in the house rules because a lot of owners don't read the declaration and bylaws. But if it's just one unit owner violating the residential use, for example, by running a business out of their unit, it would just be a straightforward enforcement of the bylaws action where you would inform them, please stop doing that. And if they don't, you'd have to consider mediation, arbitration, or possibly even court to get them to comply with the bylaws. So,
because typically it's supposed to be residential, so for sleeping and eating and that kind of stuff. But
yeah,
when the argument that I heard was because a unit owner, although they worked out of their house or their unit, they the objection was the volume and amount of people going in and out of the unit, which was an objection by the board because that's a lot of traffic going in and out. So conducting business from within the unit was what they were arguing about. And I kind of get it, because there's a lot of foot traffic, right?
Well, oh no, that's a good point. We would generally say, and there are sometimes house rules are adopted or board policies, that if you work from your unit, any business that results in traffic to and from the residential unit is prohibited. Because realistically, if somebody is somehow working from their unit on their computer. It's very difficult to stop that or even know whether it's going on. But no, you're right. Generally, and this section 105, 514B 105, would allow the board to adopt a rule saying any business use of a residential unit that results in people coming and going, or customers or clients coming and going to the unit, is prohibited. So that would be a reasonable use of a house rule, and it would be consistent with this 514B 105B, which is to prevent disruption of other owners by interfering with the use of their units of the common elements by owners who bring their clients or customers to their residential unit. Yes.
Yeah.
Okay. And then I think well, as we were just discussing, the scope of the house rules can be broader than simply dealing with the common elements, because as we just discussed, the house rules can include policies that are based on the declaration of bylaws. And again, that's often because people don't bother to read the declaration and bylaws, but often do read the house rules. So many boards transpose, they take limitations and requirements out of the declaration of bylaws, put them in the house rules to let owners know that those restrictions or requirements exist. So that's one of the ways. And of course, 514B 105 B is another option for dealing with things which disrupt the use of the project by other residents. And again, the fact that the house rules deal with issues other than the common elements doesn't make them invalid, as long as the board has support in the declaration or bylaws to justify the provision in the house rules. So I think that's the general thing. The starting point is they are primarily to control the common elements. And, the general consensus is that restrictions on the use of units must be in the declaration and bylaws, but the house rules can implement restrictions from the declaration and bylaws with the understanding that owners will at least be more aware of them if they're in the house rules than in the declaration and bylaws, which some owners just never read. So I think those are the principles the board has to keep in mind. And finally, as we discussed at the very beginning, the issue of due process. Even if your bylaws do not require that you give notice of any proposed changes to the house rules before you adopt them as a board, it certainly wouldn't hurt to give notice and take input politically. That's very helpful, because otherwise you get owners saying, oh, the board's jamming this down our throat. We had no idea they were going to put this restriction in. Just appeared suddenly. So that's one issue, the political aspect of changing the rules. It's worthwhile getting the owners involved in the process, even if the bylaws don't require it. I think that's something the board should consider. And then the final issue is due process. You can't change the house rules on a Monday and then start enforcing them on a Tuesday without giving due process notice. We usually recommend that if the board has changed the house rules, they send them out to the owners and they start enforcing them maybe 30 days after they were sent out, so that there's no claim. Because basically due process is a shorthand for saying that the process you follow should be appropriate for the circumstances in which you're taking the action. So that's something the board should also consider.
And there's one comment I want to add, that, the word reasonable, you have to really present yourself as being reasonable, especially when you're giving these notice to the owners of a change. There was one complaint, or, an email that came in, that the board had amended the house rules, and but there was no notice to the owners for an opportunity to respond back. But so they made them effective on a certain effective the date of the letter, but the mailing didn't go out till 3 weeks later.
Uh-huh.
So that was kind of like a little bit unreasonable.
Well, that's certainly a due process issue because again, if you happen to be dealing with a judge, if you try and enforce your new house rules, they're not going to be too willing to accept a situation like that. Because again, due process is supposed to be you follow a process that is due or appropriate for the circumstances. So sending something out 3 weeks after the house is going into effect is unlikely to meet the basic standard of due process because you haven't given effective notice to the owners of the new rules. And if you start enforcing them without the owners having a reasonable opportunity to become aware of them, and often the cover letter will say, we changed the rules on this, and this. Look at, rules 5, 6, and 7. That's an easy way to focus owners in on the main changes because generally house rule changes don't change everything. They just change certain things. And certainly if you post it to the website, if there is one, or you have some kind of way of getting the word out to the owners, that helps. And I think the final statement, you should certainly make sure that residents receive a copy of the new rules and not rely on the owner to provide them to the resident. Because if you're going to enforce against a resident and they haven't been made aware of the changes, you're going to have an uphill battle if they challenge you. Because again, that would not be considered due process of saying, well, we sent them out to the owner of your unit, so it's their fault, not ours. Probably isn't going to go over too well if there is a challenge. Yeah.
No, and so you should be prepared to send out copies twice, one that would go via mail to the owners, and then another copy that you can hand deliver to every single door.
Yes, that would be one way of confirming that everybody had notice. If you just, because again, most of the time the owner of the unit is going to be less affected by the house rules than the resident in the unit. So if the unit is occupied by a resident, that's the person you should be focusing on to get them to comply. Yeah.
And on a side note too, going back to the mailing of the notices, I mean, the board needs to be cognizant that, okay, they've assigned that responsibility to their management company to do the mailings, but the board should also double check to make sure that there's a timeline that it needs to be mailed out by this date. And then making sure that there's ample time. And if the management company can't get it out on time, they need to adjust the dates, so that they're being reasonable.
That is something the board always has to keep in mind, that if it's your responsibility, you can certainly delegate it to an agent, typically the managing agent, sometimes the resident manager, but since you're the person who's responsible, delegating to an agent doesn't get you off the hook. So as Raylene said, it's important that you not only delegate, but give a clear statement to the person to whom you're delegating something, what they're supposed to do and when. So that's true, because ultimately, if the board adopts the rules, they're responsible, even if they can't turn around and say, well, the managing agent didn't send them out on time, or that's not going to help the board. So it is true that if you're responsible, you have to make sure that what you're responsible for actually happens, and not just say, oh, I gave it to them and they're supposed to take care of it. Because you're not off the hook.
In the workforce today, it's really hard. Like, the management agent could have agreed that, okay, we'll get it out by this date, but they could have had unknown complications because of workforce. The person that was supposed to do it quit or whatever, got sick or whatever. So that could change the whole timeline. But they still have to be reasonable in getting that goal accomplished, to send the notice out or rearrange dates as they need to accordingly.
No, I think that's a very valid point, that it's not what's supposed to happen, it's what did happen. And so in a situation like this, dealing with house rules, it's what did happen, not what you asked them to do. If they weren't able to do it on time, you have to readjust your schedule for enforcement and all that. Because again, it's what actually was conveyed or communicated to the owners and residents, not what you intended to do, but what you did or what your agent did for you. Yeah. So that's a good point. I think that's pretty much the overview of adopting house rules. And we did mention early on, one of the areas of danger is anything to do with restrictions on children, restrictions on families with children, restrictions on use of facilities that may affect families with children, or disabled residents. So you always want to keep that in mind when you're adopting your house rules, because the fair housing is enforced by government agencies and they can make life very difficult. So you would want to make sure that any provisions you put in your house rules that may trigger a issue under the anti-discrimination fair housing laws are carefully reviewed so that you don't create unnecessary problems. And, this is commonly found when you have a house rule about children using the pool, using the hot tub, that kind of thing. And, when they can, how old they can be to use the pool without adult supervision and all those things. So that is probably one of the most, I don't want to say dangerous, but one of the most difficult issues in adopting house rules is, even if you're focusing on the common elements, if you adopt any restrictions that might be considered discriminatory against families with children, disabled persons, anyone like that, then you may have some difficult problems.
Yeah, and once a complaint is filed, the life gets hard.
Yes, that's very true. If anyone's been through a fair housing complaint, they'll know that it can be a very long and arduous process.
Yeah, and you want to avoid that at all costs, because it can go on for years on that complaint.
No, that's very true.
Okay, so we are at the end, and I really appreciate your time, John, doing this Condo Insider. And to everybody out there, we hope that this will answer a lot of your questions when you take the task to do your house rule amendments, if any, and also committees, because we do get quite a few questions regarding those two topics. So, John, I really appreciate your time.
Yes,
in doing this.
I would just say that maybe the main thing to keep in mind is the standard principle of judges. We always seem to see it as the big bad association against the poor little homeowner. So you should always keep that in mind when you're doing anything at your condominium project, that if it comes in front of a judge, that may be the starting point for their analysis. Yeah.
And sometimes if an owner is complaining or a tenant is complaining, well, how come I can't do? Sometimes if you also explain to them why, they may not understand the why, but once they understand the why, they kind of get it. That's
a very good point. Yeah, it is something that people don't always, they think of it as just themselves. They don't look at it in the context of how what's going on might create problems for the whole association, all of the owners. So that's something to consider. Yeah. Especially like I had someone, I had to explain to one owner, she was complaining about why the dog had to be on a leash and held. And I said, and this particular woman, I know she had an older dog. And I said, picture this. If you're walking your dog and maybe somebody else is walking their dog, but that dog is not on a leash, and and you would think a little itty bitty Chihuahua against your bigger dog would be no threat. I said, but I've seen it happen where that little Chihuahua charged the bigger dog and it got into a scrap. I said, so you never know. No, that's a very good point. Just because your dog is well trained certainly doesn't mean that anyone else's is. So.
Yeah. I mean, I was really surprised when that little Chihuahua went charging. And I'm like, wow, you little punk.
Yeah, they don't always have a sense of safety and proportion. Yep. So.
Okay. All right. Thank you, John. Okay. I really appreciate your time. Have a good rest of your day.
Okay. Goodbye then. Bye.
Thank you.